Former Wake County Assistant DA learned her punishment today for withholding evidence in a case.
WRAL's Amanda Lim has been tracking this case, and she has the details of what's next for Colleen Jansen.
Colleen Jansen's disciplinary hearing took place here at the Wake County Courthouse 10 days ago. After the 3-day hearing, Judge Donald Stevens took the case under advisement, and he issued his final ruling today. When Colleen Jansen testified at her discipline hearing on March 9th, she admitted to making mistakes. She was accused of hiding the fact that her star witness in an armed robbery case was a drug dealer. At the time, she had just returned to the DA's office on the heels of her father's kidnapping. An ordeal, she says, affected her work.
I used every last bit of mental energy that I had, and just to keep it together.
Judge Donald Stevens ruled that Jansen could keep her law license, but could not work as a prosecutor or for a government entity for 2 years. In response to the ruling, Jansen's attorneys said Ms. Jansen accepts the court ruling and will comply with it. But regardless of the sanctions, it appears that Jansen has already punished herself more than any court could.
The criminal justice system that I believed in and worked so very hard to convince others that they should believe in suffered because of my actions. And that breaks my heart every day.
Jansen resigned from the Wake County District Attorney's Office in July of 2016. She now works at Duke University for their talent identification program. Back to you.
Amanda Lim reporting there. Now, after the ruling came down, the chief counsel for the state bar released this statement. It reads, in part, it was appropriate for the Wake County Superior Court to address conduct that occurred in the case before the court. The court's order of discipline addresses the material issues of the case, and the state bar accepts the court's reasoned decision.
Her family endured a horrific ordeal. Her father was kidnapped and nearly killed. Now lawyers for former Assistant DA Colleen Jansen say that trauma contributed to mistakes she made in another case.
She's accused of prosecutorial misconduct. Her hearing began today. WRAL's Amanda Lim joins us now with what happened in court. Amanda?
Deborah, basically Colleen Jansen is accused of trying to protect the credibility of her star witness in a robbery case by keeping the fact that he was under investigation for drug dealing out of the courtroom during the trial, even asking a police officer to hold off on arresting him. Now, her attorneys say she did make some serious mistakes, but never meant to break the rules. Colleen Jansen always wanted to be a prosecutor.
This is an isolated instance in an otherwise exemplary 11-year career as a prosecutor.
But after her father, Frank Jansen, was kidnapped by gang members and nearly killed, her work became more difficult.
She was not operating at full capacity. She was not at her best. And who would be after what she went through?
State bar attorneys say Jansen asked a Raleigh police officer not to charge her key witness in a robbery, Marcus Smith, with drug crimes until after she tried the case.
She had gotten Mr. Smith to come in and cooperate, which sometimes is very difficult. And she wanted to see this case through.
She did not want her star witness to be facing what eventually would be drug trafficking, marijuana trafficking charges during the course of the Surprise Sandy trial.
Henry Surprise and Barshiri Sandy were convicted, but the State Court of Appeals later overturned their convictions based on Jansen's alleged misconduct. Now a judge will decide if she should face sanctions.
Things happen, and she made very serious mistakes, but she did not set out to break the rules.
Now, First Assistant Wake District Attorney Howard Cummings testified today that Jansen was a hard worker, a collaborator, a mentor in his office, someone who was well liked by her colleagues. The hearing is scheduled to last 2 days. She will testify tomorrow. The judge is expected to rule quickly. Deborah.
Amanda, thank you.
Severe flaws in justice system highlighted by disciplinary hearing of former Wake County prosecutor. The following post was shared with the COPBLOCK network by Lynn Blanchard, via the COPBLOCK.org submissions page. This is a repost from Blanchard's own blog, Stop Wrongful Convictions, which was originally published under the title Disciplinary Outcome of Former Wake County Prosecutor Highlights Severe Flaws in Our Justice System. Along with the submission, Blanchard stated, I mostly cover wrongful conviction cases which usually contain some level of police corruption/misconduct, but I like to expose all official misconduct. Thanks. Lynn. March, 2017. This week, former Wake County Prosecutor, Colleen Jansen learned the outcome of the disciplinary hearing to review the level of her misconduct in a criminal case. Though she deliberately withheld critical evidence from the defense and manipulated others to go along with her scheme to hide exculpatory evidence, she did not even lose her law license for a day. Instead, Judge Donald Stevens ruled that she could not practice law with a government agency for a period of 2 years. This means she can begin working as a prosecutor again in 2 years and do private practice until that time. What a punishment for maliciously prosecuting 2 men who landed in prison for over 2 years until her actions were discovered. I will describe Jansen's egregious actions in detail, but she was not the only one who participated in the willful act to hide exculpatory information from the defense. She actually had a lot of help from other public officials, which should place all Wake County cases under scrutiny. How often does this type of thing happen? Why is no one held accountable? Why are these people above the law? 2016. Colleen Jansen was asked to resign from her position with the Wake County District Attorney's Office in June, 2016 following the revelation that she withheld critical information in an armed robbery case against Bashari Sandy and Henry Supres in the fall of 2014. It was an obvious and deliberate Brady violation that prevented the accused from receiving a fair trial. The North Carolina Court of Appeal agreed and reversed the convictions of Sandy and Supres. District Attorney Lauren Freeman later dropped the charges against them. They withheld evidence. The fact that Jansen's star witness, Marcus Smith, was a drug dealer was the foundation of the entire defense case. This fact supported the story of the accused to such a degree that there could have been no trial without it. Background: Sandy and Supres told police that they confronted Smith to collect money or drugs because Smith had been shorting them on marijuana purchases. Smith gave them money and jewelry, and then gunshots were exchanged. Smith shot Sandy in the leg. Smith sustained a gunshot wound to the arm. It is unclear who fired that shot, but it is not relevant to this article. Smith told police that he was a victim of an armed robbery. The state accepted his story, ignoring the statements by Sandy and Supres that it was a confrontation about a drug deal. Sandy told Raleigh police that Smith was a big-time drug dealer. That resulted in police requesting permission from a judge to place a GPS device on Smith's car. Smith's impending charges. Jansen continued building her case against Sandy and Supres despite knowledge that Raleigh police were pursuing her victim, star witness, in the armed robbery case. In the summer of 2013, Jansen contacted Detective Battle via a private email address and asked to meet with him. She asked him to hold off on arresting Smith until after her trial because she allegedly didn't want to spook her witness. Never mind that the impending arrest of the witness/drug dealer should have negated the whole need for any trial since it supported the defendant's stories, not the state's case. Raleigh police complicit in misconduct. Officer Battle agreed to delay Smith's arrest. Since police had been watching Smith, they learned the location of his stash house. Upon discovery of this information, Battle gave Jansen a heads up about the probable cause and search warrant of Smith's drug house. He clearly informed her that Smith would not be named in the search warrant and he would wait until he left the premise to search the property, thus avoiding the need to arrest Smith at that time, since it could jeopardize Jansen's case. Never mind that taxpayers trust that police will make the appropriate arrests at the time of the known crimes. In fact, over 500 pounds of marijuana were found in the stash house. Battle's cooperation gave Jansen the ability to conceal the fact that her star witness was a drug kingpin at trial. Impending federal charges. Due to the amount of drugs found, this became a federal case. Lawrence Cameron with the U.S. Attorney's Office would be handling the case. He became aware of the fact that Raleigh police held off on making the arrest per Jansen's request. As a former assistant DA with Wake County himself, he knew Jansen and contacted her to discuss the status of Smith's impending charges. According to Cameron, Jansen did not want to hear anything about it. Deliberate denial would prevent her from violating discovery rules, and she was fine with that. Prior to that particular call, she had in fact asked Cameron not to arrest Smith until after her trial. Cameron was concerned enough that he got his supervisor, the U.S. attorney, involved. John Bruce contacted Howard Cummings, Wake County's first assistant district attorney and Jansen's supervisor. He informed Cummings that he had received information that Raleigh police were holding off on making an arrest at Jansen's request. Cummings told Bruce he would take care of it. Ada Cummings testified at the disciplinary hearing that he had a discussion with Jansen and that she informed him that the search of the stash house yielded nothing that could be traced back to Smith, and that his name was not on a single search warrant. That was the end of it. Cummings testified that nothing was discoverable. It's likely Cummings and Jansen believed the truth would never be revealed, and it wouldn't have been if not for the federal case. It's extremely bothersome that Cummings was willing to look the other way, despite being contacted by the U.S. attorney and informed that a fellow Ada deliberately told police to hold off on an arrest. Why did he allow the trial to proceed? Why didn't he intervene? It is the win at all cost mentality of so many prosecutors. Truth doesn't matter. Trial of Sandy and Supres. Judicial misconduct. Just weeks before the trial was scheduled to begin, Detective Battle sent Judge Ridgway an application for a GPS monitor on Marcus Smith in connection to his drug trafficking, and he signed it. It was also sealed. Since Ridgway was the trial judge, he became aware of information that impeached the state's star witness, the mere fact that the witness was being investigated for drug trafficking. This placed the judge in a difficult predicament and also further lessened the defendant's right to a fair trial. From the appeal document, PG 29-30. On October 21, 2014, 1 week before trial, Judge Ridgway considered Raleigh Police Department Narcotics Detective J.A. Battle's application to surreptitiously place and monitor a GPS tracking device on a car used by Marcus Smith and belonging to his living girlfriend. The application stated that a confidential informant alleged Smith sells large quantities of marijuana, and that the most recent report was made in April 2013 when robbery suspect Barsharai Sandy told the police Marcus Smith was a known drug dealer with over $1 million in product in a stash house. On this basis, Detective Battle stated, "It is believed that a GPS unit attached to Marcus Smith's vehicle will provide relevant information regarding where Mr. Smith stores illegal drugs." In fact, the GPS tracking authorization had already enabled Detective Battle to locate and seize 150 pounds of marijuana from Smith's stash house in August of 2014. Marcus Smith himself had been seen at the stash house before the seizure. On the basis of Detective Battle's affidavit, Judge Ridgway signed the authorization, finding there was probable cause to believe that the placement, monitoring of and records obtained from the electronic tracking device are relevant to an ongoing criminal investigation. Judge Ridgway also ordered the application and order to be placed under seal. None of the information was provided to the defense. The judge should have either unsealed the record or recused himself from the case. He did neither and presided over the trial. Prosecutorial misconduct. The star witness perjured himself as he testified that he hadn't sold drugs since 2005. The prosecutor knew it. The defense suspected he was lying but had no proof, even though it existed. The judge also knew the witness was lying. Colleen Jansen was brazen enough to discredit the defense's attempts to show that Smith was a drug dealer. This was her statement during closing arguments. There has been absolutely no evidence from the witness stand outside of the defendant's testimony that this has anything to do with drugs. Nothing that the police found, nothing that Marcus said. the defendants are the only people who've been talking about drugs, outside of that small amount of marijuana that Detective Grimaldi found in the garage and that was photographed and you saw. That small baggie of marijuana. From that, the defense wants to make you believe that Marcus Smith is apparently this drug kingpin. If that is the case, that apparently that's their position, but please think about whether or not you've heard any evidence from the witness stand that would support that contention or whether you just heard it from the lawyers. The jury found them guilty. The prosecutor's unethical behavior is absolutely appalling. Appeal. The appellate attorney representing Sandy and Supres became aware of Smith's federal case and also received a copy of a letter that described how Raleigh police delayed the arrest of Smith at the request of Colleen Jansen. When attorney Paul Green contacted Jansen to try to determine the source of the information, she delayed getting back to him for several weeks. At that point Green contacted Howard Cummings, who refused to speak to him about the matter, even though he needed to confirm or deny the allegation about Jansen for his client. Jansen finally informed Green that she had no notes or emails from any such meeting with Detective Battle. Green did his own research. He reached out to Smith's attorney and was given the content of the private emails between Jansen and Detective Battle. Days later, Jansen found her private emails, likely knowing that Green would end up getting them eventually. She emailed them to Green and he filed a motion for appropriate relief, citing prosecutorial misconduct and Brady violations. The Court of Appeals ended up overturning the convictions of Sandy and Supres, and the Wake County District Attorney had no choice but to address the matter. Jansen was placed on paid leave and eventually asked to resign. The disciplinary investigation followed. Disciplinary hearing. Jansen blamed her negligent behavior on the fact that her father had been kidnapped 6 months prior by an imprisoned gang member she had prosecuted. You can read about that here. Luckily her father was rescued by the FBI and he is fine. However, it is rather pathetic that she used her father's ordeal as an excuse for her behavior in this case. Evidently it worked, thus the almost non-existent punishment. At a minimum she should have lost her law license, and since her deliberate malicious prosecution led to 2, very likely, innocent men being sent to prison, she should have faced prison time, but that is never the case. Prosecutors are routinely able to get away with destroying lives with little, or no, consequence. Jansen testified that she made mistakes, and that she never made the connection that the drug arrest was significant to her case, even though she knew it was certainly crucial to the defense case. I don't believe her. It was no mistake. She talked about how she would have never willfully done harm to the office. Who cares about the reputation of the office when people are paying a huge price for her actions? Prison time. As well, so many Wake County officials testified on her behalf about how she was so honest, hardworking, etc. Namely, former District Attorney Colin Willoughby, who fought against Greg Taylor's innocence claims, Judge Becky Holt, who did a poor job with the Jason Young case, Judge Gessner. You can learn more about his unethical tactics in the Brad Cooper case. They all came to her defense, even knowing how deceitful she was. That's the reality of our justice system. How many more cases like this exist? How much information has been withheld from defendants? Why is there a mentality to win, rather than seeking the truth? Why are public officials, who are paid with our tax dollars, never held accountable for their misconduct? My hope is that the public will become more aware of cases like this. You can watch the disciplinary hearing here. Lynn Blanchard, wrongful conviction advocate. Contact lawblanchard@nc.rr.com.
Hey Charlotte County, this is Charlotte County COPWATCH, and I wanted to explain what fair use is. You can use pieces of news articles if you're doing it for news reporting, you have commentary, and you're doing it for education purposes. So that's what fair use is, as you can see right here. Another reason why I wanted to make this video is to let you know I have just joined with Patreon. A nice thing with Patreon, I make no money on YouTube. They took the money away years ago. And so this is another way to give, and it's a nice thing too because you can give monthly. You can give $1, $5, $10, whatever. I do 4 to 5 hours a day on trying to wake the sheeple up on how corrupt it is and different ways that you can fight the corruption. So Patreon is a way that you can do it, and then of course the old way is still there. Donate to Sheriff County Cop Watch with PayPal or credit card. So keep that in mind. 4 to 5 hours a day. I make no money, but the corruption happened to me and I'm sick of it, so I'm trying to wake people up. But my wife would love it if if we could get some help out there. There's 47,000 subscribers. Just think if each one of you subscribers just gave let's say actually yes, $1 a month. 47,000 subscribers gave $1 a month. That would be awesome. That's not going to happen. But anyways, that would be great if it did happen. But do the math in your head. Just think about it. Like I said, 4 to 5 hours a day. I get no money from YouTube. YouTube has gone nuts. You can't do anything anymore. They're taking the money away everywhere. So these are a couple different ways that you can still help out with all this time that I put in. And as you know, I'm in a special situation where, at least I can do it, 4 to 5 hours a day. We have a cleaning company during the day. That's what allows me to do this, and we're debt free. So this is my hobby. I don't go fishing and all that other crap. I try to save the world. So help me out to make the wife happy, man. In fact, if you guys did give $1 a day, and there was 47,000 of you, and you did it, and each of you gave $1, and that was every month, oh my God, yes, I could quit. I could start suing them. Another idea too that we have is, if I got, some funds, we could actually contact everyone that has been ticketed and or arrested and put in jail and start sending them postcards to let them know we're here, and to see if everything went all right, and if it didn't, find out their story. So we could even do more investigations and more lawsuits. Lawsuits take money. So just think about that. 47,000 of you so far right now. $1 a day. $1 a month on Patreon, or $5 a month Patreon, 10, 20, whatever. Just do the math in your head. Help out. This is a lot of work every single day. Thanks.